a willing prospective licensee. Now, I emphasize the word willing there, and we'll get to that in a moment. The reasons for this are various. Doctrinally, one might argue that a FRAND commitment itself can be viewed as a commitment, a contractual commitment of sorts, that the SEP owner is prepared to offer a license on FRAND terms. As far as economic theory is concerned, particularly when we are dealing with SEPs that are needed to implement complex products, the concern is that a patent holder armed with an injunction could extract an ex post royalty that would reflect not only the economic value of the invention in comparison with alternatives, but also some portion of the implementer's sunk costs, its higher switching costs. And so that would tend to over-reward the patent holder in comparison with its contribution to the art. So one way or another, we are converging on this general rule that there's no injunction to be had against a willing licensee. Now, injunctions still would remain available and still do remain available against non-willing licensees, and the reason for that is that we don't want to discourage bad behavior on the part of implementers, what is sometimes referred to as holdout, where the implementer might delay negotiations, delay paying a royalty, hoping that it will gain some benefit. In some countries, damages might not be fully compensatory if prejudgment interest is not routinely awarded, which it often is not outside the United States. But if the would-be licensee is a willing participant, then no injunction. Now, how we get to that result will vary from one country to another, and so we've had some cases in the U.S. in which the courts have invoked contract law as a basis for that. That might work in France as well, since France also appears to recognize a doctrine that a FRAND commitment creates a contract for the benefit of third parties. Another possibility would be in the U.S. Simply to apply eBay, and so in applying the eBay factors, again, as long as the defendant is a willing licensee, it often would seem to be the case that the award of a FRAND royalty as damages would be an adequate remedy at law, that there would be no irreparable harm, et cetera, et cetera. And that possibility may exist in other common law countries where injunctions are discretionary, albeit even in the UK, Canada, Australia, they're not as discretionary, I would say, as they are in the US under eBay. Third possibility, there is this doctrine in civil law countries called abuse of right. Perhaps its closest analogy in US law would be something like the patent misuse doctrine, although this is not applicable just to patents. It applies to any sort of right. But this concept has been invoked in Japan, in the Netherlands, in some standard essential patent cases as a basis for denying injunctive relief against a willing licensee. And then a fourth possibility, at least in the European Union and possibly in China and maybe some of the other countries outside the US as well, would be to invoke antitrust or competition law. And so we actually have a decision of the Court of Justice for the European Union from 2015, Huawei versus ZTE, in which the court set forth this framework whereby there are certain steps that the patent holder and the implementer, if they follow them, would result in no injunction being awarded. The theory is that for the owner of the patent to seek injunctive relief against a willing prospective licensee can, in some circumstances, amount to abuse of dominant position in violation of antitrust law. So I'm not going to go into the details of what this framework is, but it contemplates the patent holder making an offer, the implementer perhaps making a counter offer, some sort of negotiation between the parties, and if those steps are followed appropriately, then the defendant may be able to avoid being enjoined. So that's a possibility. And so we've seen applications of this, of course, in Europe, in the German case law. China appears to be following something very similar to the Huawei versus ZTE standard from the European Union, and there's been some Chinese case law just in the last couple of years. Some cases in which injunctions have been awarded against defendants who were found not to be willing licensees. They were delaying the process of negotiating. And the Chinese courts from time to time have issued these guidelines. And so this is still an evolving body of law in China. But the CLE materials that I presented, that I gave to Alexandra Givens, you'll have access to all of these materials if you're interested in them. Courts are still working through some of the fine points on this. For example, is the failure to follow the Court of Justice's framework, does that mean that the patent holder is abusing its dominant position and therefore cannot obtain an injunction? Or is the framework merely intended as a safe harbor? So if you do follow these things, then you would be able to get an injunction. That was the holding of the English court in the recent Unwired Planet case that I'll mention in a moment. How much scrutiny should a court give to the initial offer that is going from the patent holder to the defendant? Does the initial offer itself have to be FRAND, or does it just have to be sort of FRAND, at least in the range of FRAND? How closely will a court scrutinize it? We're getting different opinions on that from the German courts. Anyway, if a court then is ultimately called upon to award monetary relief, if an injunction is denied, let's say, then there's a question about what the damages should be, and at least outside the United States, the question is sometimes posed, if the defendant really is at fault in some respect, the defendant did delay negotiating and so will be enjoined, but also has to pay damages for any harm that has accrued before the injunction. Is the plaintiff only entitled to a FRAND royalty, or could it get its normal damages, whatever that might be? Maybe the normal damages would exceed the amount of the FRAND royalty. That may well be the case in Germany, South Korea. To the extent a court is going to determine the amount of a FRAND royalty, there's really two general approaches that are emerging for doing that, and they are usually referred to as bottom-up and top-down. So briefly, the bottom-up methodology is very closely analogous to the methodology that would be used to award a reasonable royalty. And so that means that, at least in theory, we're trying to reconstruct the bargain the parties would have agreed upon ex ante. There's a question about whether the SEP owner is entitled to any of the value that accrues from standardization itself. The U.S. courts have largely said no to that. The English court in Unwired Planet thinks that that would be possible. The problem here is that applying the traditional reasonable royalty methodology in this context is very difficult to do, so courts typically will fall back to factors, Georgia-Pacific-like factors, not necessarily identical to the Georgia-Pacific factors, but focusing on things like comparables, the value of the patent in suit to the user, the extent of the use, and questions of apportionment. And comparables in particular in this context raise a host of issues. Do we actually have good comparables? What about confidentiality? In Germany in particular, their courts are trying to work through some sort of procedure to ensure that comparables disclosed in litigation are not revealed to the world. Under what circumstances might a patent pool rate be comparable? So there are a lot of issues. It is fair to say, however, that when comparables of some sort are available, courts seem to be receptive to using them in FRAND cases. We've seen that in the U.S., in the Ciro versus Cisco case, in Microsoft versus Motorola, where Judge Robart looked to pool rates, among other things. The English court in this recent Unwired Planet versus Huawei case relied principally upon comparables for the patents in suit. And we've seen that in some of the case law in some other countries, in China and India as well. So that's one way, so-called bottom-up. The other approach, referred to as top-down, means roughly the following, that the court will make some kind of determination about what the aggregate royalty burden is for a particular device, such as a smartphone, and then divide by the number of SEPs incorporated in the device, then determine how many of those does the plaintiff own, and then determine whether to weight them or not, or should they all get equal weight. So there are a lot of sub-issues that go into this as well. But this is the methodology that was used in the Innovatio case by Judge Holderman a couple of years ago, and much more recently by Judge Selna out in California in TCL versus Erickson, a case that is currently now up on appeal before the Federal Circuit. A different variation of this methodology was used by the Japanese IP High Court in Samsung versus Apple in 2014. And some of the Chinese courts have expressed a willingness to apply this top-down methodology in an appropriate case as well. And what we're seeing is that some courts are preferring to use bottom-up as the principal approach and use top-down as kind of a check, sort of going back and checking your work and seeing how they compare. Others, such as the TCL court, prefer using the top-down as the principal approach and then using bottom-up to kind of check on that. And ultimately, in that case, the court awarded something of a blended rate. Let me touch on one more issue, and then I will stop. But perhaps the most important issue just in the last month or so is this one. Is it appropriate for a court in one single country to award a global FRAND rate, to determine basically a global settlement, or should the court only focus on determining the remedy for the infringement of the domestic patents? Of course, as Sarah talked about, patent rights typically are territorial in nature. Nevertheless, what we've seen in the Unwired Planet case, there's another case in England also to the same effect at an earlier stage, is that the courts there will award what they call a FRAND injunction, meaning that the court will say to the defendant, I'm going to enjoin you from making, using, selling standard compliant products in our country unless you agree to a global FRAND rate, in which case there will be no injunction. And I'm not actually passing judgment on the infringement or the validity of the foreign patents. In fact, you can still go and challenge validity or infringement in other countries. There's a mechanism in the FRAND license that the court is crafting that would allow the rate to go down if any of those other patents are invalidated. But that's a way of sort of forcing an overall settlement. The court in TCL did that by agreement of the parties, and the question is whether you could do it without agreement of the parties, as in England, because on the one hand, settling things all together can be much more efficient, get everything done at once instead of having to go 200 different countries and litigating in each one of them. On the other hand, this process may encourage forum shopping, and some people are now expressing concern that there will be a lot of forum shopping or racing to be the first in line in the UK or in China or whoever might be likely to determine a FRAND rate. There also are questions about what the non-discriminatory part of a FRAND determination is, and I won't go into that because I'm running out of time, but we see a very different approach in the English court's Unwired Planet decision, which basically says that non-discriminatory still allows the SEP owner to charge a lower rate to certain companies. The court in TCL and the courts in Germany appear to take a different approach. Non-discriminatory means that you charge the same rate to all similarly situated implementers. So I will stop there. I had another slide on other issues relating to injunctions, but again, if you're interested, look at the CLE materials. Thank you.
All right. I'd like to thank Tom and the rest of our panel for a great presentation today, and I'm sure at least some of them will be around for questions afterwards, so thank you very much.
Oh, I'm sorry we ran out of time.
Good. A lot to cover.
It is, yeah.
Thank you.
Good job, John.
Yeah, it's me too. Great job. Thank you so much.
Thank you very much.
Oh, my pleasure.
Sorry I went over. But,
no, it's fine. It was fascinating.
Thanks.
So with these, the global FRAND, I saw the global FRAND in your slides, and I was like, yeah. So they do it by agreement. That's
well, in the U.S., now in Britain, it wasn't by agreement. Samsung or Huawei fought it
right,
all
yeah,
the way.
I saw that.
But here's the judge basically gives them a choice. So I will either only
Paul?
Yeah.
Hi, Sepna Kumar. Nice to meet you.
Okay. I do have some slides. I can go through them pretty quickly.
No, we're not doing that at all.
Yes,
Prepared about 5 minutes, and so I can't really stretch it to 30.
I don't think Mark sent any.
I'll have a little more slide. I have great confidence.
Enablement. What does it mean? Yeah.
Right. First, well, I prepared an hour talk. Can I
Can get it to 8 minutes. Here's a slide. It sums up everything. I'm done.
I understand. Okay, so
You all, you've been here for most of the or
Yep.
yeah, I've been here.
Yeah, exactly. So what happened?
Judge, Liberty Federal Circuit, kind of like what's changed?
Yeah. You got everything.
The Promised Land, the 101.
Yeah, basically.
What happened? PTAB versus ITC SmackDown. They didn't call it that, but
Right. And a good judge. Yeah, talking about it. Talking substantively about the Delaware judges
yeah, like all 101. Yeah. No. No.
Yeah. But it's their perspective.
Multiple judges. Yeah.
He's gonna say right. It's better before you exactly. Try to figure out how you get them to not say something that hurts your case. Well, right. Yeah, I think you're right. I mean, I think the judges
Oh, okay. That's why I asked about it. And you're like,
yeah, no, it said.
I was like,
I get what's in it for the
I
judges.
just said honorable on there. So I was like, okay, judge.
I didn't think you were asking him.
Oh.
You're asking for the judges.
No.
Right, okay.
Yeah.
It's like honorable and
See you guys
judge.
up there.
So I was like,
Yeah, for all of them.
yeah. Sorry about that.
I can do it, but if give if I forget, give me the look and just hey, that's it. Okay, sign in and register this last one. Okay, great. Okay, good. I'm going to organize my thoughts for a moment up here. Thank you. Olson. You got either first or last. It's hard.
Right,
It's hard to say.
Right. Far left, far right, whatever.
No, no, no.
Yeah.
I'm going to avoid making any sort of joke along those lines. Let's stay away from
This
that.
is going to end with someone like picking up a chair and banging it on someone's head, right? Like it's going to be that kind of panel.
Let's see if I can find something.
So Kirkland, Chicago is actually my old firm back
Oh,
in
is
the
that
day.
right?
Yeah.
When were you there?
2003 to 2005, so just a short time.
Yeah. Well, I was an associate at Kirkland, D.C. in like 95 to 97, and then I went away for roughly 20 years, and then I came back. So, not the usual path,
Right,
but, you know,
but a path.
yeah, exactly. So don't rule out the possibility of coming back to Kirkland at some point. You never
Yeah,
know.
usually not from academia, but
Yeah, you never know. Now Kirkland has a Houston office.
it's true. It's true. I've got a few students there.
Have you seen the Kirkland Houston
I
office?
haven't. They had an alumni reception, but I was out of town when it was going on, so I hadn't had a chance to head over there.
Yeah, you should check it out. It's
Yeah.
It's a pretty nice space. I was talking to the lawyers, a couple of the lawyers there. I went down there to give like a presentation, and they were. I don't know how serious they were, but they were basically saying like, you know, we got like a certain budget for the new Houston office based on sort of the budget they'd given for other offices, and
Sure.
given that real estate's a little cheaper than
Yeah,
Houston,
yeah.
they were able to get like, because they're way on the top of like, you know, one of the downtown buildings, and they have some just killer views,
Oh, nice.
and the space is all very neat and modern, so it's worth seeing.
I'll have to check it out.
It might cause you to think like, oh, maybe an of-council relationship. So how long have you been at the law school?
9 years.
9 years.
Yeah.
And you're did you go from Chicago to Houston for that, or how did you find?
I actually originally from Houston. I never
Okay.
expected that I'd end up back there. It just kind of by happenstance worked out. But I was in Chicago for. I practiced first at Kirkland, then at a small patent boutique or IP boutique after that. Went to Duke for 2 years as a fellow, clerked on the Seventh Circuit, like 5 years out of law school for Judge Ripple, and then went on the teaching market.
Okay.
Ended up back in
I
Houston.
suggested
Yeah.
that we
Well,
write an article.
that's an interesting path.
Yeah.
Yeah.
It's
Palatable.
it was one of those funny things, right? I'd always wanted to clerk. It just never worked out. And I thought, you know what, I'll just try one more time. And
Yeah.
And
No,
yeah.
it's great. That's great. It's great.
I appreciate, having done it so late, I really appreciated the experience. Like,
Yeah.
I got a
Okay,
lot-
friends, let's get
Yeah.
together
No,
for our last panel.
In some ways, clerkships
Come on and join us.
most clerkships are wasted on youth.
On youth.
Yeah.
Suzanne Michelle, come on and have a seat here. We miss you. So for the stalwarts in the room or those desirous of a free drink, I applaud you for remaining all this time. We're going to have our last panel, and I have to say this is certainly one of the most prestigious and fun groups I've assembled. Forgetting the part about this blue area, it's harder to find a more qualified group of academics and thought leaders than you'll see here. To my immediate left is Mark Lemley. I was doing an email search for Mark, so I could email him about the panel. I have many students writing papers, and I think every single student had cited at least one of your papers. So typing in Lemley on the search function wasn't very useful to get to you. But anyway, I'm glad that you're here, Mark. You're an early friend to us getting this conference organized. It's great to have you back here in Washington. Jeff Luston, I think, is a newcomer. I don't know if we were able to have you come here before. Jeff's a molecular biologist turned patent law professor. He's on the Hastings faculty and is now a dean. I remember when he was on the job market entry level, and now he's a dean. And I think it's rare to say you come to Washington to get fresh air, but when you're from San Francisco, that's the way things are now. For whatever reason you came, it's great that you've joined us. Supna Kumar was just my host at the University of Houston some months ago. She's publishing up a storm from her seat on the law faculty there. I'd like to say she's a rising star, but she's already risen, and we look forward to more work from you in the future. Good friend to Georgetown is the Honorable Paul Clement. He's been part of our intellectual community here for a decade. He's also the former Solicitor General of the United States and has argued, people like me see you as sort of a patent advocate until we look at the other cases that you argue, which run the gamut. But certainly several of the Supreme Court cases that we've discussed today were argued by Paul, and we're grateful he could join us on this panel. Let me start with Mark Lemley. We're going to have, by the way, the goal here is to have a fairly flowing, free form, and perhaps laden with frequent interruptions about some of what we believe to be the most important cases of the past year that haven't already been discussed. All right, so how about that? All right, so I have a question for Mark Lemley. Mark, do the terms public use and on sale mean the same as they did 5 years ago? I hope you realize what I'm riffing on.
Yes. There is in fact an article I wrote 4 years ago called "Does Public Use Mean the Same Thing It Did Last Year?" The phrasing of that question might give you some hint as to what I think the answer is. But let me start out by explaining why it matters. In less than 2 weeks, the U.S. Supreme Court is going to hear its patent case, Helsin versus Teva. This is, I think, the most significant patent case of the term by far, and arguably, since oil states fizzled, the most significant patent case in a number of years. It, like oil states, depends on what they do. Right? It could well be that, as in oil states, as one of my colleagues put it, the Supreme Court in the most important patent case of 10 years changed absolutely nothing. I'm kind of hopeful that they will change absolutely nothing, but here's the issue. We passed the America Invents Act in 2011, and we changed Section 102 in the definition of prior art. The overstatement is from a first to invent system to a first inventor to file system. But in the course of doing that, we also made some changes to the categories of things that are prior art. So prior art before the AIA encompassed patents, printed publications, and things that were on sale or in public use. Under the AIA, it now encompasses patents, printed publications, things that are on sale or in public use, or otherwise accessible to the public. So the question is, one question we will have to confront at some point is what, if anything, does otherwise accessible to the public mean? But the question in the Helsin versus Teva case is, did the addition of the phrase otherwise accessible to the public change the meaning of all of the other terms in that list? And in particular, does it carry with it a negative implication that if your sale or public use was not accessible to the public, it is no longer prior art? Now, this was a well-settled issue in the 140 years the terms have been in the statute. We have a large body of case law interpreting those terms, on sale and public use, and we interpret them to include so-called secret sales. You and I enter into a contract in which I sell the patented invention to you more than a year before the filing date. That's prior art under existing law. We've even applied it to public use, despite the term public. We have incorporated within the meaning of the term public use private but commercial uses, running the process in my factory for several years, even though nobody outside the factory gets to see it. But the Patent Office and some of the people involved in drafting the AIA say, no, you know what? We intended, even though we reenacted the terms on sale and in public use, we intended to narrow the meaning of those terms. The use of the word otherwise in the additional phrase otherwise accessible to the public means that only sales and public uses that are accessible to the public count as prior art. Secret sales don't count. The Patent Office took this position in its guidelines for examination. Those don't have the force of law, but they reflect the Patent Office's view. The District Court took that position in this case in Helson versus Teva. The Federal Circuit reversed. Federal Circuit said, that's not the way we've traditionally thought about on sale. We have all kinds of rules for on sale that wouldn't make any sense. We've applied the on sale bar even when there's no delivery, when delivery is set after the critical date, or even when upon delivery members of the public could not ascertain the claimed invention. That suggests that what we're interested in is not, can the public see and understand the thing that has been sold, but are you actually commercializing it and therefore triggering the bar date? Federal Circuit denied en banc review unanimously. One judge, Judge O'Malley, wrote a concurrence in the denial of en banc saying, I think basically you could characterize it as an opening brief before the Supreme Court. Here are some additional reasons why we think we're right. The cert petition was supported by a number of bar associations arguing for a narrowing definition, and the Supreme Court took the case. So, what's going to happen? I don't know what's going to happen, right? I have a suspicion, and I will speculate. We'll know somewhat more in 2 weeks. But I think the court is going to look at this and they're going to say public use and on sale mean the same thing they did last year. The Federal Circuit will get affirmed. That's not something that happens often in the Federal Circuit these days, but I think it's what should happen, and I think it's probably what also will happen. The problem with the argument that we've changed the meaning is twofold. One is that it makes a hash of some other parts of the statute. So the new AIA Section 102 has two different terms with two different sets of meanings: disclosures and public disclosures. So the argument that the petitioners made is, hey, only if this discloses to the public can it count as a sale. The problem is, if to count as a sale, it has to be a disclosure. We have no idea what a public disclosure is, except that it is something that's supposed to be different than a regular disclosure. The way we've thought about it traditionally is disclosures is a term of art in patent law. It means prior art references, things out there in the prior art. Public disclosures, I think, is intended to be a subset that actually communicates information to the public and therefore gives you a safe harbor against anybody later coming in and publishing or patenting during the 1-year grace period. But that approach makes no sense, and the language of the statute makes no sense under the petitioner's interpretation. There is an interesting legislative history issue. Some members of Congress, the day after the bill was passed, got up on the floor and had a conversation, a scripted conversation, in which they said, hey, you know what? We agreed when we passed this law, we all meant that it was going to change the meaning of on sale, right? Yes, why yes, that is in fact what we meant. Now, those colloquies have not actually fared particularly well, even in the subset of Supreme Court justices who like legislative history. I don't think they're going to fare any better here, and that's particularly true because if you followed the 7-year passage of the AIA, the legislative history actually suggests quite the opposite, right? Which is this was clearly the bill was originally clearly drafted to get rid of secret sales as prior art, but they did it by taking the words public use and on sale out of the statute. And then 3 years into the legislative process, they got added back in. And the very people who engaged in that conversation objected to that and said, no, 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 that's going to mean that secret sales will be prior art. Nonetheless, it got added back in and it stayed in the statute. So I think the people who like legislative history are going to look at this and say that actually indicates to us that that we intended this term to have the same meaning. And there's a canon of construction that's pretty well established in Supreme Court jurisprudence, right? Not patent law, but just generally in law, that if Congress reenacts language that has a settled meaning in the courts, we assume it knew what that meaning was and it gave it that meaning again. We adapted that canon in the Microsoft versus I4I case as a reason to hold on to the traditional presumption of validity even as applied to things the Patent Office never really considered. Court said, hey, you kept the presumption of validity in the 1952 statute. That's what it meant before then, so we're not going to change it now. My guess is that that's what will happen here. If I'm wrong, then this case is going to be a very big deal indeed. Right? Not just because it gets rid of a whole category of things, secret sales, because it requires us to figure out what a secret sale is. The government, as amicus, has taken the position that it's not, unless I can see and understand the product itself being delivered, unless the public has access to the product, it's not a sale at all. I think on that theory, Microsoft Word might not be on sale. Sure, we can all see and engage in a contract to buy Microsoft Word, but the software license we all agree to says, hey, this is not public information. You can't share this with anyone. You can't reverse engineer it. It would be a pretty significant change. It would also, I think, open up a bunch of other potential changes to 102. We got a bunch of other doctrines in 102 that are judicially created glosses on the existing language. Experimental use exception, the inherency doctrine. All of those, I think, would be up in the air if we say, nope, you know what? By reenacting in slightly different form, we've thrown out the settled meaning of these terms. So I don't think that's what will happen. I think this will be this year's oil states, and will go on as we have gone on before, but I could be wrong.
Yeah, for me, it's an odd statute. It reminds me a little bit about the first inventor defense statute that was enacted in response to State Street Bank, and it was the predecessor of our prior user rights statute that we currently have. And it turns out that prior user defense was never invoked. It was really just applied by the Supreme Court to say that we can't get rid of business method patents wholesale. So the effect, the congressional intent was sort of warped. You know, having worked on the Hill for a long time during the enactment of the AIA, the general sense was, look, we're trying to put in things like poster boards and other things that aren't really comfortably printed publications. So let's just say that they're otherwise available to the public, poster presentations or PowerPoint slides that are distributed at a meeting. Printed publications, maybe, but they fit under this otherwise available to the public rubric. But it turns out the main effect might simply be to change on sale. Mark, what about secret uses that are public uses? What do you think about that? Would that be imperiled as well? It's a double public now.
Definitely. And I think actually, I mean, one of the interesting things about this case and how it was, the fact that it came up first is, I think from the perspective of the Supreme Court, the argument that public use includes secret use is just a much harder argument than on sale includes secret use, because it's got the word public in there, right? And yeah, for many, many years and for good policy reasons, we've interpreted that to include some non-public uses, but you can easily imagine a justice who's not particularly interested in patent law, but is interested in plain meaning, looking at that and saying, hey, it says public right there in the statute. By contrast, that same justice would have to do the opposite in order to reverse in this case. They'd have to say, you know what, even though it doesn't say anything about public, it just says on sale, and even though it was on sale, we're going to import a publicness requirement. And I think that's an uphill argument. That said, there are both the Patent Office and a lot of bar associations that are behind it. You got a question in the...
Yeah, go ahead. Could you proceed to the microphone and also just quickly identify yourself? We should at least enforce that policy for the final panel.
Yeah, thanks for making this more interactive. The question I have is, the Federal Circuit recently came up with a decision in the GoPro case where it said that the GoPro catalog, which was made available in an action sports camera-related show was intended to reach the public, and therefore reverse the PTAB's decision. So where do you draw the line to say something is public disclosure or something that's intended to reach the public? Is there some way to define who the public is?
Yes. So this is the GoPro versus Contour IP case. I will note in the interest of full disclosure, I argued and won that case. So I have some bias on this issue. It presented a kind of similar issue. So this was a catalog that GoPro had taken to a trade show, but it was presented not as a question of on sale bar. It was presented instead as the question of whether that catalog distributed as a trade show is a printed publication. Now, there's a very simple strategic reason for that. In the PTAB, you can take printed publications as prior art. You can't take on sale bar. I think the answer is there would be little question that under at least current law, distributing a catalog to hundreds of people at a trade show attended by thousands of people with an offer for the product would put it on sale. It was a harder question, I think, for the court, though I believe they got it right, whether that catalog was itself a printed publication and therefore something the PTAB could consider. The PTAB said it wasn't a printed publication, it wasn't disclosed sufficiently. Federal Circuit reversed that decision.
Right, I'm loath ever to disagree with Mark, but on this one I have to, because we currently have the right policy. The Supreme Court likes stare decisis, but only for its own cases, not for anybody else's. And so there's not a stare decisis issue here. The Supreme Court takes cert in Federal Circuit cases in order to reverse, and the court is more of a plain meaning court. So I understand where you're going with the on sale public. I wonder if anyone else would brave into this zone and make a perilous prediction here.
I won't make a prediction, but I actually have a question. Mark, do you have a sense of how many of the on-sale cases involve what we might call secret sale versus public sales?
I think the answer is it depends a little bit on what we define a secret sale to be. I mean, under the government's definition, maybe quite a few of them do, right? Because we have a whole bunch of cases, including Supreme Court cases, that involve sales of products that are not themselves disclosing of the invention, right? The interior material in the wall of a safe in Hall versus McNeil, for instance. Now, if you don't go that far, right, and you say, well, it's just about kind of, is this a one-on-one transaction versus a I am offering to the world transaction, then maybe the number goes down, but I think it's probably still half. That is, a lot of these cases are not cases in which I have put this on sale to the world. They're cases in which I am entering into commercial contracts, often because the nature of the invention is not something that I offer to the public at large, right? It's something that I offer to individual companies with whom I'm in a contract. One case I think that would have to sort of come out the other way is Pfaff versus Wells, which is the Supreme Court's most recent on sale bar case. Right? That sale involved a contract to deliver semiconductor boards to a company by an individual who hadn't yet made the boards. Question in that case was, can it be on sale even though you haven't yet made them? The court said yes, but we would never have to get to that question under the petitioner's view here, right? Because there's no way that sale was public to the world. The only people I'm selling it to are the people I'm negotiating with.
And I guess just to sort of give you my 2 cents on thinking about this a little more from the perspective of a Supreme Court generalist, I guess I'd say 2 things. I mean, I'd say that, Mark's prediction should be appreciated for its boldness because from the, if you just look at the dynamic of the Supreme Court not only granting cert in a Federal Circuit case, but having the Solicitor General weigh in and urging the court to reverse, the prediction that the court will nonetheless affirm, definitely gets points for boldness. And, luck favors the bold, I'm told. So Mark may end up being right. I'll just give you, I think that the court, when they look at this case, and this is something I believe to be generally true, but I think this case will will illustrate this point. The problem with the court from the perspective of patent specialists is when the Supreme Court gets a patent case, they don't think about it really as a patent case. they think about it as a statutory construction case. And you can explain a good number of the Supreme Court's reversals of the Federal Circuit over the years just by the Supreme Court looking at the text of the statute and then looking at Federal Circuit precedent that has a bunch of other bells and whistles that aren't even particularly tethered to the statutory text, and the Supreme Court's just not that impressed with the bells and whistles, and they are very impressed with the statutory text. Now, I don't think that describes this case really, and I think this case actually raises a general question of statutory interpretation that is interesting certainly to me, and I think will fascinate some of the justices. And I guess sort of, my bold prediction that I'll put out here is that if the court were looking at this statutory text and the statutory text was enacted in one fell swoop, then the Supreme Court would reverse. Which is to say, if they were just parsing this text and they knew it had happened on the same day in Congress, none of them would care what Senator Kyl said on the floor. I'm pretty sure of that. But what they would care about, and they would probably think is the single most important word in the statute, is otherwise. And they would look at that and say, that word otherwise not only tells us about what happens in what they might think of as a residual clause, but that tells you what is the character of every one of the other things in this list. And so all the other things in the list, including on sale, have to have at least some degree of, sort of a public availability or disclosure to them. And so I think if they were just looking at it in the first instance, they would probably pretty firmly come down that way. But then the question is, okay, given that that was a late addition, do we think about that as, in a sense, casting sort of less interpretive light on the other provisions in the list? And I think they well might, but I think a lot of the debate may well take place kind of in those terms as a general principle of statutory construction rather than being sort of too focused on kind of patent law specific concepts.
Right. I just want to jump in. I just wanted to jump in and say, I really hope Mark is right. I'm crossing my fingers and saying a silent prayer that Mark is correct. But I fear from the majority of the court, this is a court that's really stuck with plain meaning and that's rejected the general idea of bringing in background principles into statutory interpretation. And given the fact, given the Solicitor General, given the fact that they granted cert on this, I can't see this ending well.
At the same time, I think, Paul, you're right to focus on the word otherwise, but that assumes a certain meaning of public. And as the Supreme Court's own case law says that in Egbert versus Lippman, a single member of the public is the public. And so a sale made to one person, even if secret, could be considered available to the public, depending on your definition of public.
I suppose that's true, and they may parse it that way, but I think they will, again, my sense is they're probably going to be kind of more focused on sort of what does that mean? You're making an argument that, even if this all was put in one fell swoop, if you could at least assume that public just meant one person, they would come out in a certain way. I'm a little less sort of persuaded that that's the case, and so I think more of the focus is going to be on this. What does it mean that they added it later? Did they really mean to cast any different light on the previous terms in the list? But we'll see. I also think on sale, frankly, is an interesting statutory phrase. And it's not the same as just sold. Mm-hmm. And, I think if you were looking at it as a matter of first impression, I think you might say that on sale really has this connotation that you're making it available for sale to kind of more than one entity, and it really is kind of on sale to the public, which is, a little different connotation than I think if it just said sold. So I continue to be kind of, a little worried about what the court would think as an original matter for just looking at the text. And so to me, I think, where the argument where respondents may have their best chance is to try to persuade the court that, not sort of overturning the apple cart in the Federal Circuit will get you somewhere, but it certainly hasn't been a sufficient argument for respondents in plenty of other cases. So I think you really need to buttress that with a more textual-based argument that says the fact that this was added later really counsels in favor of interpreting in a different way than if it was all there in one fell swoop.
It takes a special audience to appreciate Section 102. And so here we have it. But now let's move on to a somewhat hotter topic, which is Section 101 patent eligibility. Jeff, do you want to go to the lectern, or should I hit them for you? Okay.
So I will be at the lectern, but you can feel free to interrupt, and Jay, feel free to poke me when I'm taking too much time, because we all know that Section 101 can expand to fill all available space and time. So I don't think I need to go much into the background of the cases for this audience. What I want to focus on is in particular how the Federal Circuit and some of the lower courts have been applying the steps of the Alice Mayo inquiry, step 1 and step 2, with respect to laws of nature and abstract ideas. And I'm just really going to summarize some of the 2018 cases. Now, at lunchtime, the director gave us his vision of the promised land of Section 101, where we will all rejoice and dwell happily forever after. But I'm afraid the rest of us are still wandering in the wilderness, thanks either to the Supreme Court or the Federal Circuit, or both. And yes, tip of the hat to Peter for the metaphor. So the main problem, of course, is that Alice and Mayo tell us that the test is whether a claim is directed to a fundamental principle, and if so, it has to contain a further inventive concept, without defining what either it means to be directed to or defining what an inventive concept is. Also remember that in Alice and Mayo, the ostensible rationale of these cases is the preemption rationale that these fundamental building blocks should be off limits because they're the engine, if you will, of future developments. But it becomes rather difficult to discern that rationale once we get down to trying to parse that language of directed to and inventive concept. In particular, as I'll talk about in the last part, this inventive concept is really getting quite blurry, and the boundary between step 1 and step 2 is becoming hard to discern. And one issue is that there are a couple of different notions of inventive concept running around in Mayo. One is the notion that the application has to be inventive, something beyond the routine and conventional. Another notion that it has to be something that's not generic, which has had more traction in the abstract idea space. But turning first to laws of nature, the Federal Circuit early on in Ariosa versus Sequinon endorsed a pretty hard-line view of Mayo, saying that in order for a claim directed to a law of nature to be patent eligible, the inventor had to apply that discovery with some sort of inventive means. And so using a means, in that case PCR, that was known in the prior art, could not supply an inventive concept. Now, and indeed, even though the claim as a whole might have been novel, if the individual steps were not novel, the claim could not satisfy step 2. Now, the Federal Circuit has pulled back from Ariosa a little bit in some of its subsequent cases, but the Ariosa rationale still has traction at the lower courts. Is Judge Stark still here?
No, he's back in Wilmington.
Okay, good. He's probably ruled on at least 3 motions by now.
Yeah.
Okay. Something went wrong with my clip art here because the first half of this picture was supposed to be an automobile drive shaft. And the quoted language is a case that Judge Stark wrote holding that a method for producing this automobile drive shaft was a law of nature and thus ineligible under Section 101. And what the patent was about was the inventor asserted that by creating a liner inside, this is an automobile transmission, and designing the characteristics of this liner according to certain laws of physics, like Hooke's law, that you could damp certain modes of vibration within the transmission and thus reduce the vibration transmitted from the engine. And the claim was challenged on Mayo grounds, or Ariosa grounds, if you will. And the section that I've reproduced, the interpolations are not actually mine, they're the district court's. And what the district court concluded was that all this claim did was to take certain laws of physics, like Hooke's law, which has been around since the 1600s, and apply them to the design of an automobile transmission with routine and conventional steps. And therefore, this claim apparently represented nothing more than a law of nature. Now, you might be forgiven for thinking that at least prior to Mayo, using the laws of physics and mechanics to improve a device was known as making an invention. Apparently not. What I think this illustrates is that currently the test for whether a claim is directed to a law of nature or abstract idea is so amorphous and indeterminate that once the cases tend to just be ipse dixit, I declare that this is an abstract idea or law of nature under step one, that if you fail step one, it's very, very difficult to survive step two. And I think this claim points out that it's not apparent what role 101 would be playing in a claim such as this. I mean, there were probably some 112 issues with the claim, but certainly if we're asking whether the inventor made an inventive application, well, Hooke's law has been around for hundreds of years. So either the inventor, when the inventor decided to apply Hooke's laws to a drive shaft, either that was something inventive, an inventive application, or it was obvious. Because if it wasn't obvious, then why had no one applied Hooke's law to the design of an automobile drive shaft before? So for me, the case emphasizes that it's very difficult to see why we have a 101 doctrine in cases like this. And furthermore, I mean, this is a case where the patentee had not discovered Hooke's law, but if you're okay with this claim, and I imagine most of you are probably okay with this claim being patent eligible, then this raises the further question, if the patentee had further discovered Hooke's law, then why is it that we would deny him that claim? Ironically, exactly the same argument was resolved by the Court of Exchequer in a case about 180 years ago that became part of the foundation of American patent law through its incorporation in the hot flask cases. This was a case called Minter versus Wells about the design of a chair based on the use of a self-adjusting lever. And the defendant had argued, you've done nothing but monopolize the principle of mechanics, and the Court of Exchequer said, no, you've simply designed a chair using the law of mechanics. This is a machine, not a principle of nature. So we seem to have gone considerably backward since Minter versus Wells. So particularly in light of Vanda, that I'll talk about momentarily, it's probably unlikely that this case would survive appeal to the Federal Circuit. But when we get to the Federal Circuit, it's quite clear that if you have a diagnostic claim, that you will not survive. And the case from Roche versus Cepheid illustrates this case, the principles pretty well. That the case involved the inventors had determined essentially certain signature features of the tuberculosis bacterium DNA, certain unique segments of the bacterial chromosome that were diagnostic of the tuberculosis bacterium. And so you could just take a sputum sample from a patient and rapidly amplify the DNA to diagnose whether he had tuberculosis, rather than doing a culture and waiting for that culture to grow. And the case illustrates the bind that Mayo and Myriad put any inventor of a diagnostic in. So the correlation between the presence of the signature sequences and the presence of the bacterium is a natural correlation. And given that the inventor used only conventional means of DNA amplification, then the method claim becomes ineligible under Mayo and Ariosa. The other claim was the composition claims to primers, certain short sections of DNA that are complementary and are used to amplify the signature DNA. Those, because they're identical to the DNA sequence of the natural bacteria, become ineligible under Myriad. There's not really anything new here. I only want to point out that Judge O'Malley has an interesting concurrence in the case where she argues that the Federal Circuit might want to revisit its primer jurisprudence, suggesting that these primers, even though they're identical to the nucleotide sequence of the bacteria, might still be eligible under Myriad. This seems like an unlikely argument under Myriad, but it does point out that Myriad does not definitively commit to whether nucleotide sequence or chemical identity is the essential characteristic of DNA that determines whether it's a natural phenomenon or an invention. And so there's theoretically some wiggle room given how loosely Myriad is written. Okay, but the big case I think is the Vanda case Peter already alluded to this morning. And Vanda was an ANDA case, and the claim in substance, or the invention in substance, was very, very similar to Mayo. So it involved the method of treating schizophrenia patients with the drug iloperidone, and the drug poses a dose-dependent risk of certain complications, certain cardiac complications. And a patient's cytochrome P450 genotype, a certain gene, determines how fast they metabolize the drug, and so therefore what dose you should give the patient. So really the same invention as Mayo, except the difference between the Mayo claim and this claim is that this claim included a step of adjusting the patient's dosage of the drug depending on whether or not they were a fast metabolizer or a slow metabolizer. And so Judge Lurie in Vanda ruled that this was a method of treatment claim as compared to the diagnostic claim in Mayo, and therefore, as a matter of step one, this claim was not directed to a law of nature. And picking up on the language from Mayo that a new use of an existing drug would be patent eligible, the court declares that a method of treatment is not going to be a law of nature under step one. Somewhat unfortunately, the decision also seems to re-inject preemption into the 101 inquiry, which I had thought the Federal Circuit had really beaten down. Judge Lurie suggests that the Mayo claims were broadly preemptive because they did not they didn't prescribe a particular dosage, and so they tied up a physician's treatment determination, as compared to these claims where there's a specific dosage required. I mean, I suppose what Judge Lurie is arguing seems to be that a physician is free to ignore the genetic test and prescribe a different dosage anyway, which doesn't really seem any less preemptive. The physician could ignore the genetic test, never order the genetic test to start with. As far as diagnostics go, or personalized medicine patents, because this is a personalized medicine patent, I think the decision may have some fairly limited applicability. What's significant in the case is that it was an ANDA case. It was not just an ANDA case, but it was an induced infringement ANDA case. So the question was, would there be infringement if the generic was approved and went on the market? Because I think there would probably be a significant divided infringement issue in this claim, because the claim requires the steps of performing the genetic test and then prescribing the drug. For reasons that are not clear to me, the defendant in the case did not raise a divided infringement claim. The only evidence in the case that someone did this was the plaintiff's own expert, and the plaintiff's own expert even said that he sent the DNA test out to the lab. So whether or not you're going to be able to get a useful claim that will survive a divided infringement challenge is not clear to me. Interestingly, the patentee seems to have tried to forestall that by using the language obtaining or having obtained a biological sample and performing or having performed a genotyping assay, seeming to suggest that the person doing the prescribing might not actually be the one doing the genetic testing. This language was not debated in the case, and we might as a panel debate whether that kind of having obtained language would really get you anywhere.
Jeff, I'm a little confused about that. So wouldn't the physician be the one be responsible for the common control, and then he would be the drug company would be inducing the physician?
So the question is the degree of control sufficient to satisfy the Federal Circuit's test for divided infringement? And forgetting the case, it's the Eli Lilly case.
Yeah, it was Lilly, right?
Yeah, where there was the question was, would the physician tell the patient to take a dose of a drug, I think after another drug, I don't remember that. And that was where the prescribing indications on the label said, tell the patient he must take this drug after the other drug. And so that was enough for the court to determine that there could be joint infringement. Not clear to me that the label here doesn't say you must perform a genotype assay. One interesting question would be for some drugs that are approved by the FDA only on condition of some sort of a personalized medicine test.
Great, thank you. To the students here, we're going to do this case on Monday, so read up. Okay.
No.
All right, thank you.
Okay.
All right, thank you, Jeff.
Like I said, you can tell me to shut up any time, because I'll go on indefinitely.
So Jeff, can I just jump in on this case?
Sure, go for it.
Are you still?
No, I'm done on Vanda.
Okay. I mean, do you agree with Peter? This is indistinguishable from Mayo.
The invention in substance, yes. The form is different.
But do you think that matters? It's hard for me to imagine if this case went to the Supreme Court, right? The Supreme Court doing anything other than summarily reversing and saying, hey, this looks like Mayo to us.
Again, it really depends on what you think of in Mayo. If Mayo is really a case saying you can't just put forth the natural law and saying, here's the natural law,
and say apply it,
then maybe you reverse. If you see Mayo as a case demanding inventive application, then maybe you get a different result. I mean, Lurie does point out the quote marks in his text here are from Mayo itself. So Justice Breyer, in criticizing the claims in Mayo, said these claims are not like claims for a new use, a new way of using an existing drug. So I think, I don't know, if Peter and I could convince Justice Breyer, he might not reverse. But it's certainly the case that the form of the invention is no different than in Mayo. And if you will, it's not clear that the policy rationale is any different, because as I said, I find it hard to accept Laurie's argument that this claim is any more preemptive of the underlying natural relation than the claim in Mayo was. But dovetailing then, any more comments on Vanda? Dovetailing with this notion that you're only going to survive if you integrate the adjustment or treatment step into the rest of the claim was another decision by Judge Lurie, Praxair versus Mallinckrodt. And the Praxair case involved claims that involve supplying a cylinder of nitric oxide to a patient and then informing the patient or including a recommendation that you shouldn't give nitric oxide to patients with a certain condition that could make the treatment deadly. And so the question would be, in the case was, did this step of recommending to the patient that they not take the nitric oxide, did this have any patentable weight? This was not a 101 case, it was a 103 case from an IPR. And the novelty of the claim was not, of course, in just supplying a cylinder of nitric oxide, but accompanying it with this recommendation that you shouldn't give it to the patient with that condition. And what Judge Lurie held is that mental steps should be treated equivalent to printed matter for purposes, at least of a 103 analysis. And so this included critically not only the steps like providing information or recommending, but one of the claims had a step of evaluating. And Judge Lurie said that evaluating should be treated like a printed matter as well. And so the upshot of this is what treating a claim limitation as printed matter entails is that it have to have a functional relationship to the so-called substrate in order to receive patentable weight. And if I have a claim that just says give someone a cylinder of nitric oxide and recommend that they don't take it, in Judge Lurie's view, that did not establish a functional relationship. In contrast, one of the dependent claims that said discontinuing or avoiding the nitric oxide treatment if the recommendation is to not give the patient nitric oxide, that established a sufficient functional relationship. So any mental step claim that's standing on its own won't get you anywhere. It has to be tied into the treatment. I will comment here, it's a tragedy that this case wasn't decided before Mayo, because if this case had been around before Mayo, the Mayo determining step would have simply fallen out of the equation. We would have simply had a claim for administering a thiopurine drug, which would have been a very easy case. This case, as I said, is not a 101 case, it's a 103 case, but the principle that any mental step is treated equivalent to printed matter should apply to 101 as well. Open question, I think, whether it would extend to the performance of that evaluating step by some electronic means, given that this was purely a mental step case.
There are cases that say mental step can be mental step done in a computer. But so what would it mean in the 101 sense to have it drop out? I mean, would we just not count as part of the claim any of the computer-performed data steps?
Well, not that they wouldn't count, but they have to have the functional relationship to the process as a whole. So if the claim recites a result, then that probably suffices. That's a reasonable relationship to the substrate. So I think it's only an issue probably for claims like this where you're trying to get around divided infringement or you're trying to avoid questions of inducement and trying to get a portion of the whole diagnostic or therapeutic supply chain, if you will, trying to capture that in one claim. So that's probably the biggest weight, which arguably was the case in Mayo. So again, unfortunately, my visuals have come a little off. I want to talk briefly about the Exergen case, which is a non-prac written by Judge Moore and has one of the best illustrations I've seen in a patent. And it was a case about a new way to take body temperature. And what the claims involved was simply taking a thermal scanning device, which was known in the art, and scanning it over the temporal artery, one of those throbby veins when you get angry. And what the patentee had done was established, as you can see by part of the graph, a mathematical relationship between the skin temperature over the temporal artery and how that related to body core temperature. Because, of course, your temperature right here is not the same as your body core temperature. And the claims really recited nothing but moving a detector along the skin and computing the core body temperature. So really a diagnostic method that doesn't seem to involve anything other than a natural correlation. What Judge Moore suggested in the case was an approach that was utterly contradictory to Ariosa, because she said that, well, the patentee incorporated that discovery into an unconventional method. That is, the method as a whole is unconventional because no one ever used the mathematical relationship when they were scanning temperature before. This is in contrast to Ariosa, where the Federal Circuit said that the means of implementation were all known in the prior art. And so this suggests a more integrated approach, a bit like along the lines that Andre was suggesting this afternoon. Judge Hughes has a dissent in the case pointing out quite rightfully that this is contradictory to the Federal Circuit's precedent in Ariosa.
But is it, I mean, I guess I understood this, the supposed novelty to lie in the fact that, like, nobody takes temperature from the skull in the prior art.
Yeah, and
so that I am actually physically doing a different form of diagnosis, not just calculating something differently, right?
That's exactly the same as in Ariosa, because in Ariosa, no one was amplifying DNA from the maternal bloodstream because they didn't think there was any DNA in there. No one was doing that before. Federal Circuit didn't care about that. They said the means are still old, and so you fail step 2. So I can't see any meaningful distinction between this case and Ariosa. One only imagines the internal discussions in the case that led to it being non-precedential. So I think we can probably see why. But it's interesting to see to what extent, and I can't remember the third judge on the panel, if this represents a majority approach on the Federal Circuit, we could see a turning away from the strict approach of Ariosa and bringing the law of nature cases, at least, more into a practical application standard. Should I go on to abstract ideas? Or, all right, so I'll just briefly, because I know other people on the panel are much more versed in this area than I am. The questions I want to focus on is how the Federal Circuit has addressed step 1 and step 2 in the 2018 case law. Now, the court has said the nominal distinction here is in step 1, is between improvements in computer technology and the use of computers in aid of processes that focus on or are characterized by abstract ideas. I think what the big problem in this case law is that we have very contradictory, or at least amorphous definitions of what an abstract idea really is. Historically, prior to, say, Benson, abstract idea in patent law meant in contradistinction to practical. We had abstractions, and then we had practical applications. So the original definition of abstract idea was something without a practical application, like the law of gravity and isolation. Sometimes abstract has meant intangible, as distinguished from the physical. In Alice, abstract idea seems to be fundamental concept, one of these building blocks. But in practice, in a lot of the Federal Circuit's case law, abstract idea seems to be something that is vague or generic. And so, looking at the 2018 cases, I'm not going to claim that this is the only way to characterize them, but it seems that there are at least 2 different strains of thought here. That we have the Alice-type cases where the abstract idea is some sort of commerce or organizing human activity and mental steps. And so perhaps our distaste with this type of claim represents a technological arts test. On the other hand, the other cases that identify abstract ideas in step 1, I'll simply call these the 112 light cases, because the deficiency in the claim in these cases seems to be either that the claim uses result-oriented functional language, or that the claim lacks specificity in its description of the abstract idea. And note that most of the cases in the second category are improvements in computer technology. They're just very poorly described and very broadly described improvements in computer technology. So it's not clear to what extent we can use this notion of step 1 of separating improvements in computer technology between the use of computers to facilitate other things. That doesn't quite seem to map out the direction that the Federal Circuit has taken in step 1. And then finally, I'll wind up by talking about step 2 very briefly in Atrix and Berkheimer. We talked about the procedural implications this morning. When Judge Moore talks about, though, what you're actually proving in step 2 becomes a rather confusing morass of different concepts. So the factual allegations, both in Berkheimer and Atrix, that are supposed to survive step 2 are that the software makes the computer run better. So it uses less RAM, it uses less storage space, it runs faster. And these don't necessarily seem to indicate that the improvement is something other than routine and conventional, but at least on my reading of the cases, Judge Moore winds a couple of different concepts into step 2. So she winds in the notion of improvement, which is nominally a step 1 case, although Judge Taranto had an opinion today that acknowledges the intertwining. But so it melds the notions of improvement, of non-genericness, and non-conventionalness all into some confusing morass in step 2. So I say good luck to the district judge who's trying to pick apart what step 2 really means after these cases. And finally, just a comment that, again, I find it very difficult to pick apart step 1 and step 2 in the cases. So this is the claim from Berkheimer. And in particular, I'll point out to claim 4, which was the claim that the Federal Circuit said potentially contains an inventive concept. So in Judge Moore's opinion, she says that, well, claim 4 is directed to an abstract idea. It's directed to the notion of parsing, storing, and evaluating data. However, this storing the reconciled object structure in the archive without substantial redundancy is a potentially inventive concept. Personally, I have a hard time understanding why the steps of presenting and parsing and evaluating are abstract ideas, but storing a reconciled object structure in the archive is an inventive concept. So maybe my fellow panel members have a better sense of where that division lies. But in these claims, it becomes very difficult to discern what is the abstract idea that gets us into stage 1 with the potential inventive concept that might rescue the claim at step 2.
So, I mean, I guess I understood Berkheimer to basically be saying, right, not this is an inventive concept, but hey, patent owner at least made a sufficient showing that there's a fact question as to whether there's an inventive concept in there.
But
I agree that that requires us to get past the abstract idea piece, and I'm skeptical.
Yeah. No, you're absolutely right. But the alleged inventive concept is this storing a reconciled object structure. That is what Judge Moore identifies as potentially, she doesn't hold that it is, an inventive concept. And I just have a great deal of trouble discerning why that's an inventive concept and not an abstract idea in itself, except to the extent that, going back to Atrix, apparently this, the part in red makes it run better. And so in Judge Moore's formulation, the parts that make the computer run better, apparently we evaluate as inventive concepts. That raises the question if I have some computer implemented way of implementing commerce or voting or whatever these other no-nos under Alice, but I make it run faster or using less RAM, does that get me past step 2? Possibly.
I mean, I think the answer to that is yes, and that's. I would have said a year ago that we were kind of settling on a line in the IT cases in which if it looked technological, like it was really actually improving the operation of the computer, you would get a patent on it, right? And if it didn't, right, if it was just using a computer to do non-computer things, you wouldn't get a patent on it. I think that line has now been blurred by a bunch of cases this year, but this case, I mean, that piece seems consistent with that. If you believe, right, this is at least arguably a new and improved way of making the computer operate better, then it seems like it fits that framework. I'm not sure I believe that, but the court says there's a fact question there. Can I raise one procedural piece off of these cases? Because it wasn't discussed in the panel this morning with the judges. So both in Berkheimer and in Atrix, court says, oh, hey, in fact, on step 2, is there an inventive concept? There's a fact question. There's a dispute as to was this new, how conventional was it, et cetera. That fact question needs to be resolved. It's not clear who resolves it. The assumption on the court panel this morning was, well, therefore there's going to be a jury trial. And we started talking about jury instructions. I don't think that's right. I certainly don't think it's right that there is a right to a jury trial on this issue. It is not the kind of issue we had jury trials on in 1791, which is the Seventh Amendment test. It looks a fair bit like the claim construction question, right, where we say the ultimate question is a legal question. It may have some subsidiary facts in it, but it's the district judge and the markman here hearing, not the jury that is going to resolve those subsidiary fact questions, because there's no right to a jury trial on this issue. Judge Moore, actually, in the Exergen case, another reason it's odd that it was non-presidential is the first person to sort of raise this issue, having denied summary judgment. We're sending this case to trial. Now, in that particular case, she said there's an interesting question, an important question as to whether that trial would go to a jury or not. We don't need to resolve it in this case because you waived your right to a jury trial.
Yeah, so it's dictum in a non-prac opinion.
Yeah,
So
but that issue is coming, and it is not at all obvious that the kind of default assumption that people are making, which is, fact question, summary judgment denied, must go to a jury, is in fact the right assumption.
So last question, since Jay's told me to wrap it up, though. Mark, do you think it would be treated differently than the Graham inquiries?
Then
the Graham inquiries for 103.
Well, so yes, I mean, so the line to divide is, right, why is it we take a legal question with subsidiary facts in claim construction and say judge decides it, and in obviousness and say jury decides it. Whether or not we should actually be saying the latter is an interesting question to me, but if there's a distinction, if there's a reason for that distinction, it's because juries were deciding issues like this in 1791, right, that juries were making 102, 103 type determinations. They were not explicitly making 103, but they weren't making 101 determinations. Now, that said, the Alice framework looks more and more like a 103 determination, so you could imagine a court saying, well, gosh, we weren't giving patentable subject matter to juries, but now that it looks like an obviousness determination, maybe we should be.
Yeah, and I just, add one thought to all of this, which is just, I think you make a compelling case that, maybe there's a better case in Vanda for that to be distinguishable, and that Exergen, maybe is a case that, based on what the court articulated, it just looks like it's not faithfully applying the Supreme Court's test. I would just say, though, if I had a magic button that allowed me to have one of those two litigants call me to do their cert petition, I would sure rather push the button that said I'd like to take Vanda up, and just because I think that is, and I think Mark said something along these lines, but I think that will feel like it's a circumvention of what the Supreme Court had previously said in a way that Exergen wouldn't, and I think that may just, I guess I'd say that for make 2 points there. One is, I do feel like Vanda would feel to them like this is too close to what we've already decided. But I also think that the way the law is likely to develop here in the Supreme Court is less that they're going to be focused on exactly how the Federal Circuit in a particular case formulated their own standard that they know is not really working that well, because I think they know all that. I think what's going to prompt them to get back into this is a determination about a specific patent that just feels very wrong to them one way or another. That either, no, this is exactly what we said is not eligible subject matter, or something where they look at it and they say, no, the Federal Circuit has overinterpreted what we meant to do, and this thing looks to us like an invention. And so we're going to jump back in, and now maybe we're going to tweak the test. But I think that's how the law is likely to move forward on this issue.
One substantive area that the U.S. Supreme Court has not addressed with respect to patents is enablement. But there have been some important developments. Sunma, are you going to take them up from the lectern, or should I hit the buttons for you? Right.
So I'm going to be talking about trustees of Boston University versus Everlight Electronics. But what I really should have called this talk is enablement, not dead yet. We all thought that it was dead. We've spent all our time talking about 101. It seems to have really just displaced 112. But this case shows us that there is still some hope for bands of enablement. So this is a semiconductor case. Boston University holds a semiconductor patent, and the invention addresses the issue of the development of these thin gallium nitride films. And why these are useful, you can use them to make blue LEDs, and fabricating these gallium nitride films has proven to be very difficult because there's not very many substrates that have the correct lattice structure that matches the gallium nitride. So at issue in this case, this is claim number 19, and it's a pretty simple claim to understand. You have a substrate, you have a non-crystal single, a non-single crystalline buffer layer that's grown on your substrate, and then on top of that, you have a growth layer that is grown on the buffer layer. And I should point out for the substrate choices, as far as I'm aware of, gallium arsenide is not a term. I think they meant gallium arsenide. If this is a fancy, like, British spelling, feel free to correct me, but I think it comes from a misspelling from a 1975 article. So, at issue, the terms that I have in red, non-single crystalline buffer layer and grown on, these got interpreted in such a way that the court said that there were basically 6 different permutations with regard to the relationship between the growth layer and the buffer layer. And I'm not going to go through all 6 of them because 5 of them were found to be enabled. What we care about is the 6th permutation, the monocrystalline growth layer formed directly on an amorphous buffer layer. And here is where Boston University ran into trouble. So the sole technique in this patent that's described, it's called epitaxy. It's a method, or a process rather, for growing a crystalline layer on top of another crystalline layer. And unfortunately, it won't work at all when you're dealing with growing a monocrystalline layer on top of an amorphous buffer layer. And Boston University tried very hard to argue that this was enabled. They got testimony from various scientists who had successfully grown a monocrystalline layer directly on an amorphous buffer layer. Unfortunately, there was 0 evidence that any of these people achieved this great feat by reading the specification for this patent. And so the court was not very impressed by this, saying, well, that doesn't show us your specification is actually teaching a person skilled in the art how to make this. And Boston University also tried to argue, well, 5 of those permutations are enabled, so it shouldn't matter what the 6th one, the 6th one shouldn't really be an issue. And here the court emphasized the fact that the specification must enable the full scope of the claimed invention. So even though 5 of the 6 different permutations on this relationship between your buffer layer and your growth layer are in fact enabled, the fact that the 6th one, there wasn't anything in the specification teaching a way of achieving this, that wasn't enough to meet enablement. And you really saw the court in this case emphasizing how patents need to teach the public how to make the invention, and that's part of the quid pro quo of the patent bargain. So why is this interesting? Well, we've seen this long line of tangled up, confusing 101 cases, and so it might bring us a little bit of hope that maybe we can move back to a simpler era of limiting patent claims based on 112. There also appears to be some traction in the PTO in terms of a more robust 112 examination. So I think that it's interesting for all of these reasons, and I will open things up to the panel.
So this is a really interesting issue because it's worth thinking about kind of how you do genus claims under this case law approach. So on the one hand, we have a bunch of cases that say, you know what, a certain number of inoperative species, that's not going to kill enablement, right? The only question is, have I enabled you to do this without undue experimentation? Yes, you need to make and use the full scope of the claims, but in Atlas powder, we're making dynamite combinations, and it turns out 40% of them don't blow up, but the court says, well, that just means you got to try 2, maybe 3 times with different combinations, and you'll get it. So you have enabled all of the operative species within this genus. What's different here, I think, if there's anything different, is that the species you didn't enable turns out to be operative and potentially valuable, and it's just that you didn't actually find it.
Yeah, and that they're trying to claim it after the fact.
Right, and right. But it's sort of like if that same species had been inoperative, I assume that the case would have come out the other way.
And that's what I think. It's the fact that it turned out to actually work, and their specification didn't teach anybody how to do it. That became the problem.
But that's not something we're going to know at the time, right?
Yeah.
And so Jeff is actually who's been
Oh,
thinking
yeah,
about this problem.
Well, yeah, I mean, it is a strange case. I mean, in one sense, it was peculiar the inoperative embodiments doctrine didn't seem to appear in that case, because, I mean, one could call it inoperative, that if one tries to grow the crystal layer on an amorphous layer, then it simply doesn't work. But the notion that, well, there was 1 out of 6 embodiment was not enabled is silly. There are millions and millions and millions of non-enabled embodiments in the claim. So, for example, I doubt that the patent specification allowed you to grow a functional layer that was only 1 atom thick. We don't have that technology yet. So that's a non-enabled embodiment within scope of the claim. We don't focus on it, maybe because maybe the defendant wasn't practicing that embodiment. Actually, I can't remember, Safna, was the defendant practicing that non-enabled embodiment?
I don't think they actually were. I don't think it was the 6 permutations specifically, but they were just raising the general challenge that because the claim language encompasses this possible permutation, that they didn't properly enable the claim.
I was going to say, there's this other body of law, I think Judge Rader had some cases long ago, this notion that a patentee only has to enable so-called nascent technology. They don't have to enable technology that's far out in the future. And if 5 years from now someone develops a way of doing it this way, we'll say this was that non-nascent technology that they didn't have to enable.
Right, and I mean, I think if you just read this as everything that could possibly be within the scope of the claim you must have enabled, right, then it's creating an impossible burden on anybody who owns a genus claim. I think that's not how it's going to be read. I think it's going to be read to say, hey, you know what, your invention was not any deposit. Your invention was any deposits usable that could be done using molecular beam epitaxy. That's what you did. That's what you described in the specification, and that's what 5 of the 6 things. And so, if you had added a limitation, right, deposits made using molecular beam epitaxy, we would have said, fine, you can have an enablement, and we would have glossed over the problem that Jeff points out, which was all claims have a potentially infinite number of things we haven't yet enabled. But that you didn't do that here, and you actually wrote a claim that because it didn't include that process limitation, encompassed things that other people could do using other forms, but that you hadn't taught us.
It could have been a much cleaner case, possibly on written description grounds, if you simply say that the patent doesn't contain a description of anything formed on an amorphous layer, then it seems like it's a much easier case.
Yeah, I have just one quick comment and then a question for you. The comment is just as I read the opinion, it seemed to have a little bit of this flavor of, this is what you get for sort of broadly construing the claims, and that it was sort of suggesting that there's a trade-off there. And so it did seem cognizant of that. It didn't seem particularly cognizant, though, about the other point that you were making, which, to me is the more interesting thought here, which is that, maybe if you developed a more coherent 112 jurisprudence, it would take some of the pressure off of the 101 jurisprudence. I mean, do you think that's what was actually going on here, or do you think it's just kind of interesting because it sort of has the potential?
I think it just has the potential. I don't think we have any signal yet from the Federal Circuit that that's what they're intending to do. I hope that that's what they're intending to do, but no, there's nothing in the opinion that mentions 101 or gives a clear signal that they're changing directions.
The Federal Circuit often tends to not recognize the generality of its precedent, by which I mean that sometimes the biotech 112 cases and the chemical, or maybe I'm not sure what you would call this, engineering 112 cases and the software 112 cases, they don't necessarily seem to relate to each other. So one wonders, to what extent the pharmaceutical precedents were argued in this case.
That's a good point.
Okay, we seem to have come to an appropriate pause in our discussion. So I will do what many American law professors do at the end of classes and the end of conferences, which is indulge in a maudlin moment of parting observations. But before I do that, I'm going to.
Jay?
Yes.
Do we want to do return mail for 1 minute? Up to you.
Sure, Mark.
No,
Why
up to you.
not?
Up to you.
You have some modeling observations yourself?
No,
Go
feel
ahead.
free to.
Yeah, we can do. Do you want to go down the row or
Oh,
any-
no. So there's one case, one
yeah,
Supreme
that's
Court
right. You wanted
case
to get the shot in. Go ahead.
that we have not talked about that's on the docket for this term, and that's the return mail case. This is not likely to affect very many people very much.
Yeah.
The Supreme Court sometimes has an instinct for the capillary on IP issues, right? It's taken 2 copyright cases this year, neither of which matter much, I think, in the...
Hey, one of those is mine.
But we might get a perfectly good decision, right? It's just not going to change the overall law.
Come on, non-taxable costs? I mean,
that was not the one that... Yeah.
It gets me a quiver, right?
They took, right, last year it was Western GECO, right, the third...
Hey, what are you picking on my bases for
the
again?
third, well, this is a
Come
sign
on.
that you've done well, right? If you've got the court's attention to these cases, you're doing something good, right? But that was the third of the 271F cases that they have taken in 10 years. As far as I can tell, there have only been 3 271F cases in 10 years. The Supreme Court has taken all of them. So this might be another one in the kind of like, well, they'll make this decision and no one will care. So the question in the return mail case is the government a person? For purposes of bringing a PTAB challenge. The post office here brought a PTAB challenge to a mailing patent, and the statute says any person can bring a challenge. So the question is the government a person? I don't actually have a strong view on one way or the other what the right answer is. I will say we know from prior Supreme Court and circuit precedent that corporation is a person. Right? We know from last year from the monkey selfie case that a monkey is not a person for IP cases. So I guess you could characterize this case as asking whether the government is more like a business or more like a monkey.
Okay, sadly, it is time for us to part. So I'm going to, on that note, so I'm going to make 2 quick factual points. So one of them, depending on your taste, will be the most important thing you heard all day. So the first is we're serving drinks in the back. Okay, so when I'm done, you can go back there. The second is that if you seek CLE, you must go through 2 steps, and they are listed at the close of the agenda. Okay, see these are the 2 blue things there. So first, as a nod to the printed matter doctrine, you must physically sign some piece of paper back there, right? And the second is you have to hit the hyperlink and follow the directions that are listed in the program. Okay, so they're both listed after the agenda. Okay, so it's always a great pleasure to get to enjoy the intellectual discourse that we have. It wouldn't be possible without the 2 people sitting here, at the very least, Alex Gibbons, our executive director who takes the laboring oar getting all of this through, and I understand arrived in D.C. last 3 in the morning. So I can't believe you're still with us in any way, shape, or form. But we're grateful for your efforts, and of course also for Peter Manel and our colleagues at Berkeley who make such an effort to get this together with us. I'd really like to thank our speakers. Without we can't have a conference without the speakers. Many of the speakers have come from far away to join us. They've endured smoke from massive forest fires on the West Coast, slush and freezing rain here on the East Coast, and loathsome airline food. In between, the third surely is the worst. But they've gone through all of them, and we're grateful. And more seriously, we're thankful for the time taking out of your schedule to come here to join us in Georgetown. We thank our sponsors. Again, without sponsors, we have no fiscal ability to hold this conference, and we're also grateful for the intellectual contributions that our sponsors have made as we shape the content of the program and come up with speakers. And again, I thank Cisco, Intel, Google, Verizon, and Samsung very much indeed, and I hope you'll consider working with us in the future. Last, I'd like to thank all of you. Thanks to all of you for getting through the conference. Many of you have been here all day. Some of you back and forth a little bit, but again, without your participation, we can't hold this. We enjoy having you here at Georgetown and contributing to the intellectual life of our community. We hope that you'll come again to the 11th annual conference, which should be next year. So let's have one last round of applause, and I'll see you at the bar.
Section 1983, the Supreme Court has held that a state